Hi everyone, I'm glad that you are on here today. I wanted to take some time to make some videos as to what I have done myself, starting way back, it was 2015, and really I started to research in 2014. See, CPS came in March 11th, 2014, when my little boy was just 2 months old, and they based everything off of presumptions, assumptions, and hearsay. And our case had to do with a family member who was retaliating against us and using very dark means to do so. And what I want to do is come on here to not focus on the past, but to empower myself and others by focusing on those things that lift us up, and they don't tear us down. They help us to move forward, to rise above this, to see that we do have the power to do things, and regardless of what other people are doing, we can deflect that negativity, that darkness, the distractions away from us, and just say, no, this is what I'm focusing on. This is what I want to create. And when we use our own lights to shine on the darkness, and we move forward and we continue to create what we want to create, that's what's going to end up happening. So it's about embracing anything that is serving us and turning away from those things which are binding us. And I no longer want to be bound by other people or persons, entities, anything like that. So what I have on the screen here is a petition for a habeas corpus for cause. And I had done a lot of research, looked into different sites, and one of the first ones I came upon was Facebook, and it was a 14th Amendment citizen type of group. And anyways, someone had a link to the National Liberty Alliance, and I went back to look for it later, and it had been deleted. And so I tried to ask why that was, and the group had said that they didn't allow other groups, information about other groups to be posted in their group. They wanted to keep people focused on what they were doing, which 14th Amendment stuff is not an area that I saw as something that was helpful to actual people, men and women, flesh and blood. We're actually infinite souls living these human experiences, but I'm not going to go there right now. So anyways, I went to National Liberty Alliance and started learning more about our rights and who we are as physical beings on this planet. And I do not eat the whole plate, and I don't throw out the baby with the bathwater. I keep questioning everything, and just because I use information does not mean that every single belief that someone believes in or a group believes in, that I hold those same beliefs to be my own. But I will embrace the golden nuggets, and I see golden nuggets all over the place. So here's a golden nugget, and I am so thankful, and I will say thank you to those who are dropping these golden nuggets and who are helping and uniting and trying to share the truth and stand up for freedom for people. So I think this is about really looking and focusing on those practices and those actions, planting those types of seeds, the good seeds, the healthy seeds that are helping everyone to grow and to rise above the oppression that's been binding us through this system that wants to keep people asleep. So here is the petition for habeas corpus that I filed with the United States Common Law Grand Jury. And when I talk about the United States, what the National Liberty Alliance does is they don't get involved in the whole fraud and the use of legalese and all this type of junk that pulls people in different directions depending on what words we use. So United States, they have in here, actually stands for America, the actual country. Okay, so we won't get into corporations and all the fraud that's been pulled over people's eyes. The supreme law of the land, no matter what the commercial codes have come in and tried to do, and all these bar attorneys and men and women in seats of power hiding under corporations have done to say that no, the supreme law is this or that, other than the common law courts by the people of the people. So that is what I want to focus on. That way we don't get distracted. But this is it's basically a Marion County Circuit Court for the state of Oregon Juvenile Department de facto. This is who it was given, or it's about in my case, because I am in Oregon, the Marion County, and they had these case numbers associated with me and my family, all of my little ones, and it's all being done under statutory de facto so-called courts. And the federal case for this habeas corpus that I received and had filed and everything is 1776-1789-2015. And this is against Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, Attorney General Ellen Rosenblum. Now, the people who are on here are those who made summary judgments against us, the sheriff who did not stand up and protect our rights, and the attorney on this one is who they court appointed to my little ones. And then there's many other actors involved as well. So this is just those who were actually named right on the front, but there's others who are accountable for their actions as well. So it says petition for habeas corpus, and this is in small writing, and I'm just going to try as best I can to read this. And for those who are interested in what this is about and what is being said, because there's so much knowledge and information in this, and there's too many people who are dumbed down to what the law actually is and says. So it says American jurisprudence, constitutional law, and it's 326, free justice and open courts, remedy for all inquiries. Injuries. See, it's very small. In most of the state constitutions, and I'm going to try to make this a little bigger for me. Let's see if I can do it. There are provisions varying slightly in terms which stipulate that justice shall be administered to all without delay or denial. All right. Without sale or prejudice, and that the courts shall always be open to all alike. These provisions are based largely upon the Magna Carta, Chapter 40, which provides, we will sell to no man. We will not delay to any man either justice or right. The chief purpose of the Magna Carta provision was to prohibit the king from selling justice by imposing fees on litigants through his courts, and to deal a death blow to the attendant. It says venal and disgraceful practices of a corrupt judiciary in demanding oppressive gratitudes for giving or withholding decisions in pending causes. It has been appropriately said that in a free government, the doors of litigations are already wide open and must constantly remain so. The extent of the constitutional provision has been regarded as broader than the original confines of the Magna Carta, and such constitutional provisions have been held to prohibit the selling of justice not merely by magistrates, but by the state itself. All right, so here comes now Sherry, and it names my family, and it says, let's see, it's very hard to read, but hereafter referred to as petitioner, people of Oregon, in this court of record under Article 3, Section 2 of the Constitution, whereby the judicial power shall extend to all cases and law arising under the Constitution, and Article 4, Section 4, whereby the United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasions of rights, the jurisdiction being the supreme law of the land under Article 6. Clause 2. Petitioner hereby petitions the unified United States common law grand jury, hereinafter referred to as a judicial tribunal, for the right of writ of habeas corpus to inquire into the cause of imprisonment and restraint of liberty of said petitioner, who is not subject to the jurisdiction of the following custodians: Judge Lindsay, Partridge; Judge Thomas Hart; Marion County Sheriff Jason Meyers; Attorney Phil Wiseman; Attorney General Ellen Rosenblum, and it has their addresses there. So it says, notice is hereby given to the courts and all interested parties that case number, and it's, the case number on there, statutory, in the de facto Marion County Circuit Court for the State of Oregon Juvenile Department is removed to the de jure United States District Court for the District of Oregon Common Law for habeas corpus for cause. Petitioner may prosecute a writ of habeas corpus to inquire into the cause of the restraint. Number 1, application for a writ of habeas corpus shall be in writing, signed and verified by the person for whose relief is intended, or by someone acting on his behalf. 28 USC 2242. 2, every person unlawfully committed, detained, confined, or restrained of his liberty or property under any pretense whatsoever may prosecute a writ of habeas corpus to inquire into the cause of such imprisonment or restraint. A quote, in the United States, habeas corpus exists in 2 forms, common law and statutory. The Constitution for the United States of America acknowledges the people's right to common law of England as it was in 1789. It does not consist of absolute, fixed, and inflexible rules, but broad and comprehensive principles based on justice, reason, and common sense. Miller versus Monson, 28 USC 2243. Issuance of writ, return, hearing, decision, a court, justice, or court judge, tribunal, entertaining an application for a writ of habeas corpus shall forthwith award the writ, or issue an order directing the respondents to show cause why the writ should not be granted, unless it appears from the application that the applicant or person detained is not entitled thereto. The writ or order to show cause shall be directed to the person having custody of the person detained. It shall be returned within 3 days. The privilege of the writ of habeas corpus shall not be suspended. United States Constitution, Article 1, Section 9. Number 3, the habeas corpus is prosecuted because the taking of the people into custody was without due process in a court of law, aka court of record. The respondent's court acted under statutes and therefore was not a court of record, but rather a nisi prius court. In this way, jurisdiction was fraudulently acquired without petitioner volunteering or knowingly agreeing to the proceedings. 4, no state can deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Any court that ignores due process is not a common law court. Such action of a court that deprives or denies due process of law proves that court to be unlawful, and consequently having no legal authority over the petitioner without his consent. I do not consent. Pursuant to Supreme Court Annotated statute. The state citizen is immune from any and all governmental attack and procedure. Dred Scott versus Sanford. And then it goes into the case law. The Supreme Court has stated clearly every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow man or fellow men without his consent. And that is Cruden versus Neal. Number 5. The Nisi Prius Court is, in fact, a Nisi Prius Court false, because respondents have taken unlawful dominion of petitioner so as to deprive him of his court of law. Petitioner should be immediately released so that he may return to the jurisdiction of his own court. Any charges of incompetence or fraud on the court, see affidavits attached. All right, number 6. Petitioner herein declares he has seen no sworn document, evidence from a competent fact witness to lawfully assert a challenge to his competency as one of the people. No servant has the authority to declare differently without evidence in a court of law. Government servants cannot restrain or incarcerate people because they disagree with them. Any constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. Then, that a constitution should receive a literal interpretation in favor of the citizen is especially true with respect to those provisions which were designated to safeguard the liberty and security of the citizen in regards to the person and property. And that's 16 American Jurisprudence, and that's section 97. And you have Meyers versus United States, and then number 7. Petitioner has been subjected to unlawful imprisonment or restraint. Petitioner is thus petitioning for a writ of habeas corpus to demand that his liberties be returned. I demand that my liberties be returned. Because the respondent's court should have been a court of record, but instead fraudulently concealed its jurisdiction under the color of law, a writ of habeas corpus should issue. 8. The Constitution for the United States of America, Article 3, Section 1, grants that judges both of the Supreme and inferior courts shall hold their offices during good behavior. No judge may act without jurisdiction, and all lawful jurisdictions must be ordained and established by the people. Number 9. The Constitution for the United States of America, Article 4, Section 4, guarantees a Republican form of government and protection against domestic violence. When a judge enforces acts beyond his authority under color of law, judicial immunity is lost. Such actions are nothing less than lawless violence. Likewise, legislative jurisdiction that is not authorized by the United States Constitution is as inoperative as though it had never been passed, and judges proceeding without jurisdiction are indictable for treason. Judges are expected to know the law. Number 10, the Constitution for the United States of America, Article 3, Section 2, authorizes 2 jurisdictions, law and equity. A court of equity follows the forms and procedures of chancery as distinguished from common law. A court of equity and a court of chancery are synonymous. A court of law means court of common law, a court for the people. In alleged criminal cases, when judge claims that they are bound by legislation authorized by the Constitution as they act under equity rather than law, they commit fraud on the court. The law of the land is common law, not equity, and judges in every state are bound thereby. Number 11, equity courts are nisi prius courts courts not of record. Courts proceeding according to statutes. They have no power to fine or imprison, and to do so is a crime. Courts of law are courts of record and proceed according to common law. Number 12. Under common law, the following maxims apply. For there to be a crime, there must be a victim. Corpus delicti. In the absence of a victim, there can be no crime. For there to be a crime, for a crime to exist, there must be an injured party. There can be no sanction or penalty imposed upon one because of this exercise of constitutional right. Schrar versus Colon. 13. Constitutions must be construed to reference the common law. Summary proceedings are null and void. As to the construction with reference to common law, an important canon of construction is that constitutions must be construed to reference to the common law. The common law permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And there is no, my eyes are like crossing here, and there is no common law of the United States in a sense of a national customary law as distinguished from the common law of England, adopted in the several states. In interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. 16 Am Jurisprudence, section 114. Number 14. Respondent Judge Lindsay Partridge and Thomas Hart acted without constitutional authority, thereby without jurisdiction and under color of law, using unconstitutional statutes and summary proceedings that are null and void under common law. Furthermore, Respondent Judge Lindsay Partridge and Thomas Hart refused to identify the jurisdiction he was operating under, which clearly was not under common law, and therefore was under equity, a court not of record, a court without the power to imprison, a court without the consent of petitioner, a court thereby acting under fraud, thereby a writ of habeas corpus should issue. Because no jurisdictional basis for custody has been preferred or stated, a writ of habeas corpus should issue. Number 15. Broad meaning of jurisdiction on habeas corpus. For purpose of the writ of habeas corpus, as for purposes of prohibition or I can't remember how to say that word, certiorari, and I said that wrong, I butchered it. The term jurisdiction is not limited to its fundamental meaning, and in such proceedings, judicial acts may be restrained or annulled if they are determined to be in excess of the court's powers as defined by constitutional provisions, statutes, or rules developed by courts. Number 16. The liberty of the people is restrained by the custodians. A. Petitioner is in custody by color of authority of the state of Oregon and or the custodians, and is or was committed for trial before some court thereof. 28 USC 2241C, and then it's 1. B. Petitioner is in custody in violations of the Constitution or laws of the United States, 28 USC 2241C3. And this is where you can go to look these up in the codes. Number 17. Although the true cause of custody of petitioner has not been stated by the respondents, petitioner on information received believes that the claim of authority is under color of law in violation of the Constitution of Oregon State and the United States of America. The true basis for jurisdiction by the custodians has never been preferred or stated. Petitioner, as the people never knowingly or voluntarily agreed to such jurisdiction. Petitioner disputed and continues to dispute any false allegations that such agreement was made. 18. The jurisdictional facts leading up to the custody and restraint are unknown to petitioner. The jurisdictional facts by which the custodians presume authority to continue to deprive petitioner of a court of record are unknown to petitioner. 19. The petitioner on informational and belief alleges that the custodians are funded in whole or in part by the state of Oregon. Thus motivated, they are acting under color of law as contractual agents of their principal, the state of Oregon. 20. The court lacks personam jurisdiction because it proceeds under statutes. It therefore is a nisi prius court, not of record, and does not have petitioner's consent. 21. Petitioner did not consent and therefore is immune from any and all governmental attacks and procedures. 22. Petitioner is independent of all laws except those prescribed by nature, and is not bound by any institutions formed by his fellow man without petitioner's consent. I do not consent. 23. The custodians do not state, and the proceedings do not show any lawful authority or jurisdictional facts enabling the custodians to lawfully take dominion over a people of Oregon. Lacking such jurisdiction, their actions can only be under color of law, violating due process in order to execute their own private agendas, whatever those may be. Therefore, a writ of habeas corpus should issue. Because petitioner was deprived of liberty without due process, a writ of habeas corpus should issue. 24. Respondents proceed as a court of equity, which is not a court of record, and therefore have no power to imprison petitioner. Let's see. Conformatio Sartorum, sovereign people shall not be taken or imprisoned, or, let's see, I can't see this, deceased, or outlawed, or exiled, or anywise destroyed, but by lawful judgment of his peers, or by the law of the land, Magna Carta, chapter 39, sometimes referred to as chapter 29. 25. Petitioner responds to obsta, and I probably butchering all of these names, but principes from the beginning, and or continues the same against said, first of all, courts not of record, state or federal. Number 26, petitioner was denied due process of law, which denial of due process of law violated petitioner's unalienable rights as protected by the Fifth Amendment. Let's see. No person shall be deprived of life, liberty, or property without due process of law. Due course of law. This phrase is synonymous with due process of law or law of the land. It means laws in its regular course of administration through courts of justice. Kansas Pack Rye Company versus Dunmire. Law in its regular course of administration through courts of justice, courts of record, is due process. Leeper versus Texas. And then you can see the case law there where you can go to these cases to see what was ruled and stands. Number 27, petitioner was deprived of his unalienable or unalienable rights of due process in a court of law, aka common law, as secured by the Fifth Amendment, and therefore a writ of habeas corpus should issue. Because petitioners were the victim of and I say that wrong, but Baratri, maintenance and chaperty, a writ of habeas corpus should issue. Number 28. Petitioner charges all respondents with conspiracy to execute common verity, maintenance, and chaperty. And if I said those wrong, what is stated here stands. We are all people, and sometimes this language, we haven't been taught this, so it's hard to sometimes pronounce things, and then we get caught up in that. And I'm going to focus on what is at hand and what is truth. So I'm going to continue on. I'm almost done with this filing, and then I will share more in a different video. It says, because custodians have engaged in prosecutorial vindictiveness, a writ of habeas corpus should issue. Burdens is upon respondents to rebut presumptions. Number 29, petitioner objects to the jurisdiction and process of the court not of record. 30, the court not of record that has no power to restrain, imprison, take property, or fine, and in violation of its own corporate charter has therefore unlawfully restrained the liberty or property of petitioner. 31, respondents in violation of 18 U.S.C. 241, 18 U.S.C. 242, 42 U.S.C. 1983, and 42 U.S.C. 1985, exceeding their jurisdiction, acted under color of law, using statutes to willfully subject petitioner to, retaliatory incarceration and or restraint, while conspiring to deprive petitioner of petitioner's rights, and acted to injure, oppress, threaten, and intimidate petitioner in an attempt to prevent the free exercise and enjoyment of petitioner's unalienable rights of liberty and due process. 32, respondents in violation of 18 U.S.C. 2382 acted treasonously when they imprisoned or restrained petitioner and concealed both their actions and the hidden court, bond, chattel, money-making enterprise, operating under color of law, all acting knowingly in concert with none dissenting. 33, demand is now made to make full material fact disclosure, to see financial books of the court registry, investment system, make disclosure of the bid bond, payment bond, and the performance bond unwritten against this case, and make an offer of proof in the aforesaid matters. Demand is also made to show how the court is not profiteering by way of petitioner's incarceration. Show with clean hands how does not have a strong financial interest to incarcerate the petitioner and deprive petitioner of his constitutionally protected due process rights, and further explain how the court is not operating constitutionally infirm and not committing honest services fraud against we the people. 34, respondents exceed their authority, thereby acting under color of law to injure petitioner. 35, petitioner has not waived common law venue and insists on proceeding in a court of record, which is petitioner's unalienable right. 36, petitioner maintains position as natural woman and not a person or corporation. This application for a writ of habeas corpus is signed and verified by petitioner or on behalf of petitioner by the next friend acting on his behalf. 28 U.S.C. 2242. Next friend. Okay, a next friend is a person who represents someone who is unable to, tend to his or her own interests. Federal Rules of Civil Procedure, Rule 17, 28 U.S.C., and then it says, I, Sherry, affiant, being of lawful age, qualified and competent to testify to and having first-hand knowledge of the aforementioned facts, do hereby affirm that the following facts are true, correct, and not misleading. And my signature, and then that of my husband, and then the notary here. So this was the first filing that I did in order to stand to protect my little ones, my family, and this was done right here, you see, on the 2nd of December, and December 23rd well, this is in 2015, and then on December 23rd, CPS came back for a second allegation, and this time it was about presumptions, assumptions, and hearsay about my daughter's health and me being a fit parent or not, and caring for her in the way that parents see fit, and taking care of the causes of any type of diseases in any body. And everything was, again, based on hearsay, presumptions, and it's just wrong. And as you see, there was already paperwork in place, and people were not listening to what was taking place. They weren't listening to my voice, and so I proceeded with this, and this is what we have to do in order to stand, even when everyone else is coming against and attacking and saying, that's foolishness, put on that tinfoil hat. No, we have to stand. And I hope that this was helpful for you. I'm going to make another part to this, and hopefully it will help you in seeing the truth and seeing what actual law is. And for those caseworkers, judges, attorneys, and all these other contractors involved in this, so-called mandated reporters, anyone in these hospitals, in these schools, I mean, everywhere. Everyone is these foster care places, churches, people who have their hands in this, that have dirty hands. They need to see that you've been lied to, you've been deceived, and when you're planting unhealthy seeds, what you're going to get back is unhealthy, and you're going to reap from what seeds you have sown. And so I want to be watering healthy seeds that are helping people to rise above this and to empower, because that is what we need to do for our families. Our families are important, and we don't have to consent to things, and we don't have to give our power away, and we don't have to focus on things that are not serving us. So I thank you for taking the time to, out of your day, your busy day, to listen to me try to read this in very small print and share with you truth about, it's nature's laws that actually rule us, and we can attract things to us that either help us to grow or they destroy us. And we each get to choose this, and I choose today and forevermore to choose those things that grow me and my family despite the pushback. Thank you for watching. Namaste.